Good afternoon, Sandy.
Afternoon.
As you know, I'm here on behalf of the Supreme Court Historical Society, and the guts of what we're going to discuss is obviously merit, selection, and retention. But you know, before I get to that subject, let me ask you a couple of background questions. You know, your resume, your CV, curriculum vitae is really amazing. You know, you've done it all.
I've lived a long time.
Yeah, been around a long time and accomplished a lot. Florida House of Representatives, chairman of the Florida Constitutional Revision Commission, chief counsel in impeachment proceedings against 3 justices. You've been president of the American Bar Association. You've chaired the Florida Commission on Ethics, dean of the Florida State University Law School in the 80s, and in the 90s, actually president of the whole shebang, Florida State University. Now, with that kind of resume, how come you never ran for governor or senator or president?
Well, actually, for about a week and a half period, I did run for governor.
Is that right?
I'd announced that I was going to run for governor as an independent because I didn't like what I saw of the candidates who were running for governor. But then I became convinced that one of the candidates who was running for governor was really pretty good. And I got to know him better. I'd known him as a fellow legislator, but he took on an issue which I cared about at the time, a fair tax system. And it was, of course, it was Reuben. When Reuben agreed to adopt the corporate tax proposal, I had no more interest in running. I wouldn't have won anyhow as an independent, but it was delusional. But you know, I was young, and young people have these crazy thoughts. And I even had a very good person who was going to run with me, and he would have made a great public servant, Jim Apthorpe, who later was Reuben's chief of staff. I mean, so in a strange way, I was connected to that administration from quite early on.
I know you were born in Tallahassee.
Right.
And I know you wound up in Miami. You were at the University of Miami School of Law.
No, actually, University of Florida. I was born in Tallahassee. Shortly after I was born, we moved to Chattahoochee, Florida, a large metropolitan area just to the west of here. Lived on the grounds of the mental hospital over there. And then went to college at a small school in Tennessee called Sewanee, and then went to summer school at University of Virginia and at FSU. Graduated early and went to University of Florida Law School. I later had a connection with the University of Miami, a delightful connection in which I got a chance to teach, among other people, your wife Susan. So I did have a connection with Miami, but it was not as an alumnus. Well, I was team teaching it with Tom Wills, who was really one of the great professors I've known who cared immensely about civil rights. And
did he ever?
Yeah.
I had him. How did you become involved in this issue? Give us the background.
Well, essentially, I'd begun to serve in the legislature in 1966. I ran in Dade County. And if you ask me which part of Dade County, I ran countywide. In those days, we were running countywide. About a quarter of the state was our district. And there are 22 of us who were representing Dade County countywide. Really a sort of a strange arrangement if you care about democracy. Not an ideal system in some ways, but I had served for 2 terms, 2 two-year terms, and I was trying to decide whether to run for the third term or not. And my house was not very far away from Dick Pettigrew's house. I mean, again, we got 22 people elected countywide. I think something like 8 of us live within a 3-block radius.
Is that right?
And all in close to South Miami. And so Dick Pettigrew is one of the people. And as I was trying to decide, Dick came over to my house and said, Sandy, if you decide to run, you can have any committee you'd like to have. And that really made me think a little bit. And so I started that evening really talking it through with Dick about what I'd do if I ran. And he said, you know, you can be chair of appropriations. I said, Marshall Harris is the guy who's got to be chairman of appropriations. He's the best brain in this, in the legislature period. And he was a numbers guy, and he was really the guy who ought to do that. I wouldn't think about trying to bid for that job while Marshall's around. But what I really care about is judicial system, because I intend to go back and practice law whenever I finish my legislative service, and our judicial article's in terrible shape. And if I decide to run again, may I be chair of the Judiciary Committee and handle another attempt, be the third attempt in a few years to adopt a new Article 5. And he agreed to do that, and I decided to run. And then the nicest thing happened, Stanley, driving down US 1, South US 1, one day after work, a car came up beside me. I was in a wonderful Mustang convertible, and this car drives up right beside me, and the driver in the other car says, "Hello, Sandy, how are you doing?" "I'm fine, Janet Reno." And so Janet followed me home that day. We sat around and had drinks, and before she left, she'd agreed to become my staff director for Judiciary Committee. And honestly, that is a very important piece of this story.
I should say so.
Janet Reno was incredibly important to this whole process, as she has been to so many other processes. So I must say, one of the luckiest days of my life was to have Janet pull up beside me on US 1.
Were you surprised? And I recall when Richard Gerstein, the very long-time Dade County State Attorney,
Right.
resigned, was it Governor Askew that appointed her to that job?
It was, right.
Okay. She was not Gerstein's first choice.
You know, my guess is she was not.
Yeah, I think he wanted Carhart, who had been his assistant.
Yeah.
And then the rest is history. I mean, she became
Oh,
Attorney
yeah,
General of the United
It was a
States.
great state attorney, and in my judgment, a great U.S. Attorney General.
And you actually practiced law together in the same firm.
We
Steele Hector?
did, and we tried cases together. Yeah,
Wow.
yeah.
So a long-term
Right.
relationship. What was the background of wanting to change the system of electing or appointing appellate judges that motivated you and Governor Askew and Burton Young and Janet
Yeah.
Reno and some others?
Well, first of all, you're one of the people who probably will remember what the Dade County Courthouse looked like, the people who were around when we were first young lawyers. There were some wonderful judges. I mean, we had judges I think about today and just think about their models of what judges should be. But we also had Pat Cannon and some judges who were just colossally corrupt. People who would do obscene things, would do abusive things to lawyers and to clients.
I remember it well.
Yeah, I mean, this was, we had the sense that you really need to get into merit selection, and then ultimately, thanks to Arthur England and others, into the merit retention. So that whole movement really came in part by a number of lawyers who were very dissatisfied with the kind of system that we first started practicing in, and it was a system in which judges showed favoritism to lawyers. Lawyers had inappropriate relationship with judges. I mean, that system really was not one that I like to think about with any fondness, although I want to say again, there were incredibly good judges in the same system, side by side. But if you could have a system that would now have merit testing before you had the appointments, that seemed to me to be a much better system.
And it was actually a constitutional amendment that the voters were able to vote on, and they put in this new system.
Yeah.
So obviously they were educated to understand that there was a need to have qualified, impartial, non-political judges.
Yeah, and we ultimately did get to that point in '72, but we ought to go back to the role of Reuben Askew, because Reuben had adopted an executive order before we got the constitutional amendment, and before we had merit selection by through a constitutional legislative process. Reuben just did the damnedest thing. He gave up his power as governor. He said, I'm no longer going to be the sole person who makes decisions about who will be judges. I'm going to ask these committees of lay people and lawyers to make a decision and make recommendations to me, and I'll select from those lists. I mean, think about what an incredible gift that was to people. Who, here's Reuben, who cares about the system, wants to have really decent judges, and puts in place by executive order. Extraordinary governor. Yeah, I've always thought he might have talked to Governor Collins, who had different views about merit selection, but Governor Collins said that one of the things about appointing judges is every time you had a vacancy, there had been 10 people who had been strong supporters and good friends who wanted the judgeship, and or had somebody they wanted to see appointed to the judgeship. He said, but you had to make a decision, and after you made the decision, rather than having 10 friends,
You made nine
you had nine enemies and one ingrate. But you know, Collins, Stanley said something to me one time that just startled me. He said, you know, I don't like this merit selection process. I don't like the governor giving up his power. He said, when I was governor and there was a vacancy, I would call around the state and I would talk to people who I thought had great merit and would talk them into accepting an appointment. And I had the power right then when I talked to them to tell them that I would appoint them, and I urged them to leave their lucrative practice and take on public service. So once you have merit retention in place, you no longer can do that. So Collins was cynical about the process of appointment, but also took it so seriously.
That's very interesting, because most people would assume that Collins and Askew would have been on the same page
well,
on that subject.
Exactly. No, I was sort of shocked by it too, but he very strongly felt that, and he gave examples about talking Campbell Thornall into becoming a member of the court, Steve O'Connell, Harris Drew. I mean, he could recount these conversations he had had that he thought were very important to preserving the level of the competence and integrity of the Supreme Court, and he worried that that might slip the governor's attention if no longer the governor's responsibility.
And of course, you've mentioned the problem with various trial judges that were elected that favored friends and that kind of thing. But of course, most people think of the impetus for the change was the scandal involving 3 Florida Supreme Court justices in the 70s.
Yeah.
And I know you were very involved in that. I think you wrote the articles of impeachment.
Yes.
So tell us about that.
Well, people now forget, it was actually overlaid with the period of Watergate in the federal system, when we had all these federal scandals. But in Florida, we had problems on our cabinet. We had, I think, 3 members of the cabinet who ran into trouble of one kind or another. Askew's own lieutenant governor, Tom Adams, got into difficulty because he used state workers to work on his farm.
O'Malley had difficulties.
Tom O'Malley, a wonderful guy, but he simply went wrong. Bud Dickinson had some difficulties. Had this delightful Floyd Christian, education commissioner, who went to prison. I mean, and then we have on the Supreme Court a resignation and the impeachment of 3 justices, and then another resignation. And if you begin to look at the facts behind all those, you begin to see a Supreme Court that's dysfunctional. Now, this occurs after we get merit selection. So, so merit retention comes after this, and it comes after this in part because, in addition to Askew, we now have Art England on the court, and Art is a person who's really pushing for merit retention system. So, but that system, as you say, came out of the idea that we had 3 justices that were subject to impeachment. 2 of them resigned. 1 of them wound up staying on the court.
After he passed the mental examination.
Yeah, very decent guy, but he clearly didn't have.
Clearly not qualified.
He clearly did not have the background.
Right.
Had not been really actively involved in appellate or trial practice. Had been really sort of involved in politics, and that was his undoing because he tried to do favors for political friends, the court, when he shouldn't have been doing it.
What happened in 2010 when Justices Labarga and Perry were up for retention and they organized, a group against them? What was the background of that?
Sammy, I don't entirely know the motivation behind that. I think part of it was connected to things that were going on around the nation. That there were highly conservative groups that were worrying about the way state courts were handling cases, did not like the results of the cases, and so it got to be almost fashionable among conservative groups to go out and challenge people.
I think the only specific they mentioned, one opinion, which is also so unfair, picking one opinion on a hot button issue out of hundreds that a justice may have ruled on.
Right.
But I think what the conservative groups in 2010 used as a talking point was getting the Obamacare amendment off the ballot because they thought it was ambiguous and misleading, not because they thought it was good or bad.
Yeah. Well, and the part of the background of that, as you undoubtedly know, was that that argument before the court about whether that should be on the ballot was conducted by the Speaker of the House, Dean Cannon, and I think he was extremely disappointed when he did not win. I've watched the oral argument in that case and read the briefs and looked at that behind that case some detail. That was as shoddy a legislative product as I've seen in my years of contact with the legislature. There was a blatant attempt to try to put on the ballot something that was unconstitutional, but also try to put it on in a way in which the language of the ballot summary really misdescribed what was before the people. And any judge who thought that was a proper ballot summary or proper ballot proposal, I think badly mistaken. So I think you're right about the attack, and that attack continued in the next round of merit retention when justices who had agreed with that point were also under attack. So that case had a long life, but boy, anybody who has any real questions, I would really urge them to go back and look at the facts of the case.
Kind of amazingly, neither one of them attempted to raise money. Neither one of them attempted really to defend themselves.
Right.
Now, do you approve of that, or do you think the justices that are attacked should be permitted to defend themselves and raise money if it comes to that?
Well, I think they have to be prepared to defend themselves, and I think subsequent events have played out that way.
In 2012.
Exactly. In 2012, we wound up with another attack against 3 justices, and happily they were prepared for it and did allow people to go out and raise money for them. I think they were quite careful not to raise money themselves, but they certainly did not try to prohibit campaigns being conducted in their behalf. And I think, again, they came to this conclusion from some of the history of what was happening around the country. We had a number of examples where in merit retention elections, large amount of money came in from out of state and defeated people who were up for merit retention. And I think the three justices in 2012 were wise to stand up to that.
They didn't.
I think you're absolutely right. I mean, and the Iowa case was one of the ones. There was a case in Tennessee, then an earlier case in California where groups ganged up to try to defeat justices, and frankly, the bar did not step forward to educate people what merit retention really was about. And I think in 2012, the bar got much more involved and more constructively involved, and the justices, as you said, really stepped forward to see that campaigns were waged. And I don't like that environment. I'd love to have an environment where justices never have to worry about campaign considerations, but that's not the reality today.
What do you think about the concept of extending merit retention to trial judges? Is that something you'd like to see?
Oh, I absolutely love to see it. And Stanley,
You wouldn't have a Pat Cannon if you had
you
merit
probably wouldn't have a Pat Cannon. And I want to ask you the question that I asked my daughter, who is a trial lawyer in Dade County. Would you please tell me the names of the judges who are in the civil division in Dade County, where she practices?
There are so many.
Can you name them?
There are some, definitely not.
Can you tell me anything about them, about most of them?
You're exactly right.
I mean,
I'm sure your daughter gave the same answer.
exactly. I mean,
Yeah.
and you know, I would have given the same answer.
Right.
You know, I was actively involved in trial practice, and by the time I left Miami, there were so many judges, county judges, circuit judges. I simply didn't know them at all.
Of course.
And
You could practice 30, 40 years and still never appear once before over half the judges.
exactly. And so that's just for lawyers. Now, how about the layperson? There's no way in the world now, in small counties, you know, I grew up in Gadsden County. In Gadsden County, I could tell you who the circuit judges were who sat in Gadsden County. They also sat in Leon County, but I knew their names.
And you knew their history.
And knew the history. Small number of people. But you know, particularly now, there's so many. It's impossible for a citizen to keep track of them, and it's crazy to have contested elections for those races.
Is that a superior system, in your opinion, to merit retention?
You know, I think it is. I mean, you know, all trial lawyers worry from time to time about the possibility that federal judge suddenly gets arrogant and doesn't, you know, he really doesn't understand the human condition. But gosh, I'd take that any day against the kind of problem that you and I saw in our early days of practice. And I really worry that we're drifting back to it. That now the way elections are being held, the question of whether your name is an attractive name to put on the ballot, because that's all people are going to know. They don't know a darn thing about you.
Or an ethnic name.
Exactly. Ethnic name or attractive name, one reason or another. That's.
And your feeling is that justices who are attacked, especially by political groups with a very limited conservative or liberal agenda, should be able to defend them.
Absolutely. And I think you're right to add our liberal, because I think it's really quite possible to see this whole thing swing in a way you get liberal attacks on justices. There are members of the Florida Supreme Court who hardly ever rule for me in my cases. And yet I'd have to say that I have a high personal and professional regard for all members of the court. I think every member of the court today is smart. I think every one of them works hard. I think every one of them has integrity. And that's what I want from justices. They disagree with me. Well, all of them at one time or another disagree with me. They don't rule for my client, but that's not what I want from justices. I really want them to be smart, hardworking, and have integrity. And I think we're lucky to have the court we've got today, and that we've had, I think, for a number of years now. And
that's been the beauty of merit retention.
Absolutely, merit appointment and merit retention. You know, merit appointment becomes very important. But you begin to look at the judges, trial court judges who've come to the system through contested election, and you look at the docket of the Judicial Qualifications Commission, you begin to think that there's some overlay for the people who've been in contested elections, the people who've come through the merit appointment system. And that obviously, I'm obviously influenced a great deal by the history I've witnessed, and so much of the problems that we faced back in the mid-'70s were problems relating to the justices being politicians.
And you're like a Florida Supreme Court where during an oral argument, all its justices ask questions, unlike one justice on the
That's right.
United States Supreme Court.
Right now, and I think this has been true for a number of years. I think we've had a good court. I think they've made some mistakes. I think even some of the best of the justices, I'm a great fan of Alan Sundberg. I used to enjoy talking to Alan after he left the bench about his bad opinions. I mean, this was a discussion that we really loved having. I loved having. But we would argue at great length about some decisions he made. Look, we all make mistakes. But as I've already said, I care about having the integrity of justices, want them working hard, and want them to be smart, and we're lucky to have the people we've got.
In political terms, and especially when there are attacks on justices, where the attackers are usually coming from in recent years is, well, he's an activist judge.
Yeah.
That's the worst label, which is really absurd because judicial decisions, many of them are by their very nature activist. They change things.
Well, certainly if I had to name an activist judge or justice in the United States today, I'd name Scalia. I mean,
the most conservative.
Well, he says he's conservative, and that, but you begin to look at the jurisprudence, look at his decisions, look at the way they intrude into the decision of trial judges, and try to overturn decisions made by juries, and replace the legal principles with their own political ideas. I mean, that's Scalia's a decent guy, an awfully nice person, but I have to say he's an activist judge.
Do you see this trend toward political groups on hot button issues attacking justices even more in the future than they have in the past? Is this a continuing problem in your opinion?
Stan, I worry that it might be, and I'm quite confident it will be, if the bar and groups like League of Women Voters don't continue to step up and educate the public. But I think if there is education and good, strong campaigns pushing back, we may see this begin to disappear.
I mean, there's no question in my mind, but that the great majority of informed people, lawyers included, think that the merit selection retention, without question, has been a substantial improvement over electing judges for the many reasons you've already discussed. Now, some of the criticism of those who criticize merit retention say, well, you've taken it out of the electoral process, but hey, it's still political. It's
Yeah.
still political because the people on the Judicial Nominating Commission are insiders, they're well-connected people, they
Yeah.
know the governor, they're big shots in the Florida bar. So, I mean, how do you respond to that?
Well, first of all, I think we have to concede that a number of the people who do serve on these committees are connected, but by making that concession, I've got to say, how else do you get people on a selection committee who will have the knowledge of the performance of the people who are applying, or have the contacts to make further inquiry? I mean, honestly, I don't think it's a bad thing that someone is connected with sources of information or connected, so long, again, as they perform their duty in the way we've described them. Is there integrity? Do people really approach this with integrity? Or are they looking for somebody of a particular political stripe? I mean, this system before Askew now was a spoils system. It really was a system under which you got a group of friends and appointed them to a committee that would then select people who have been active in the campaign, given money to the campaign, and those were going to be the candidates for the judiciary. They were connected, but connected in ways that invited corruption. And so today, I mean, I don't think there have been any allegations of corruption with the judicial nominating commissions. There have been some clear indications that several judicial nominating commissions have operated in a political fashion. I'm thinking of a couple, particularly in appellate courts, but I don't think any of them have been accused in any way of being corrupt. But the old system was corruption itself.
Are there any, in your opinion, some unsung heroes who had a lot to do with getting these changes made? Because usually it's not just one or two people.
Oh no, it's so very many people. Burton Young was a great influence on Reuben Askew. Went to him and urged him to do merit selection. Janet Reno on my staff was incredibly good. Senator Dempsey Barron, who since died, was really very important. Dempsey and I had supposedly very different political viewpoints, but we got along very well, and I thought he was really quite constructive. Marshall Cassidy, the executive director of the Florida Bar, was just consistent in his support for this kind of change. Chesterfield Smith has not been unsung, but again, Chesterfield Smith is one of the large figures in this whole story, and there are so many others. In the legislature, obviously Dick Pettigrew was important, and you can go through virtually Dade, Broward, Palm Beach County delegations, Democrats and Republicans. Republicans were extremely supportive of the effort to change the judiciary, and they today you don't identify them with the idea of having a system of merit selection and retention, but because it's become so partisan. But boy, go through the people who are very much engaged, and I think you'd find some outstanding Republicans involved throughout the whole process, including the effort to get Article 5 adopted originally when it went to the people.